Employment Judge Fowl continues. On that basis, this hearing has been listed and Miss Ashwell has failed to attend. In the meantime, she has applied for the hearing to be by video and also that I recuse myself from any involvement in the proceedings. Please proofread, Judge Fowl. Do you mean any involvement in the proceedings? The last such email was sent last Friday, 12th of September 2025. In it, she states that she is entitled to a fair and public hearing before an impartial tribunal by virtue of Article 6 ECHR, but has not set out on what basis she regards my involvement in the hearing as partial. It is clear from the order made in the last hearing that a strikeout order was in contemplation before my involvement in the case. I have responded to the original application by letter. Does he mean letter? By letter on the 3rd of September 2025, declining to recuse myself, and I see no reason to do so now. It is important that such applications are not yielded to without proper reason, otherwise parties would be in the position of choosing their own judge. The tribunal's assertion that I failed to attend misrepresents the reality. I had applied to attend remotely, which had already been granted by Judge Reed prior to Employment Judge Fowl's sudden assumption of the case. Without explanation, that permission was withdrawn the following day when Judge Fowl took over. This inconsistent application of tribunal procedure directly undermined my ability to participate and defend my claim. I submitted multiple properly documented applications 5 to 6 times, requesting Judge Fowl to recuse himself due to his apparent and repeated bias. These were not frivolous requests or attempts to choose my own judge, but made on the basis of documented conduct showing a lack of impartiality. Recusal in such circumstances is a recognised safeguard under common law principles of natural justice and Article 6 of the European Convention on Human Rights, ECHR, which guarantees the right to a fair and public hearing before an independent and impartial tribunal. The test for judicial bias is whether a fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility of bias. Porter v. McGill, 2001, UK HL 67. I have consistently documented reasons why a fair-minded observer would conclude exactly that. Far from attempting to select a preferred judge, my application sought only that the hearing be conducted by an impartial tribunal, a fundamental right under Article 6 ECHR and under Rule 3 of the Employment Tribunal Rules of Procedure 2013, which requires tribunals to act fairly and impartially between the parties. Moreover, Judge Fowl appears to have taken my recusal requests personally, characterising them as attempts to undermine judicial authority rather than genuine procedural objections. This reaction itself reinforces that the perception of partiality and bias. While I do not have direct evidence of financial misconduct in this case, the respondent's conduct, including orchestrated media defamation, repeated harassment, and apparently privileged access to tribunal and police information, gives rise to a reasonable suspicion of improper influence, which requires transparency, not dismissal. Finally, Judge Fowl's statement that a strikeout order was already in contemplation before my involvement in the case does not neutralise the bias concern. It raises serious procedural questions about whether my case was predetermined without fair opportunity for me to be heard, a breach of Article 6 ECHR and Rule 47.2 of the Employment Tribunal Rules of Procedure 2013, which obliges the tribunal to consider any explanations before striking out. In these circumstances, my recusal requests were entirely legitimate. Judge Fowl's refusal to grant them, combined with his withdrawal of my right to participate remotely, has materially undermined the fairness of these proceedings.